This is Roland Mumford with Mumford.law. I'm in East Tennessee because I have 3 days of depositions this coming week representing a state employee who was terminated for reporting illegal conduct, and the state of Tennessee terminated him, and that's our allegations in our lawsuit. In most states, there is a state law that has some form of a whistleblower statute. In many states, though, that whistleblower statute may apply to employees that work for both private employers and governmental entities. Now, the other extreme is that there may be a state statute that only allows whistleblower protection for government employees. So I'm going to use the example of Tennessee and Georgia because those are states that I litigate in, but also they're on the far extremes of protection for whistleblowers, and many states are going to fall somewhere in between. So in Tennessee, we have the Tennessee Public Protection Act, and it allows protection for private or government employees that refuse to participate in illegal activity or were terminated for reporting illegal activity. But it's not just illegal activity. It's also violations of regulations or public policy. And if a person is terminated for blowing the whistle about the acts of another employee, then they can file a lawsuit and they can seek back pay, front pay, and attorney's fees and costs. It is a very broad and encompassing statute that employees can take advantage of and are protected under. In Georgia, there's the Georgia Whistleblower Act. That only applies to government employees, whether you're a police officer or you're a city clerk for a city government, or you work at your sheriff's deputy, or you work in the county clerk's office, all the way up to state employees. And I get many calls from citizens in Georgia that were upset that they blew the whistle on illegal conduct on the part of another employee, and they don't know that it only applies to government employees. Now, there are all kinds of whistleblower laws under federal statutory schemes. And one common type of claim is under the False Claims Act. And an example of that would be, let's say you're a nurse, you work in a hospital, and you learn about fraudulent billing practices by a medical provider or the hospital, where they're submitting multiple claims of treatment, maybe when in fact there was only one treatment. And they're trying to double dip or triple dip and get the federal government to pay them for multiple treatments when in fact it was just one treatment. There's all kinds of examples of fraudulent billing practices that could fall under that example. There are all types of government contractors that would fall under the False Claims Act also. Thank you very much for your time.